Anyone who's telling you that it's normal for attorneys to be writing these unattended subpoenas like the one that Blake had written up for Stephanie Jones is gaslighting you. Plain and simple. Because when they say, oh, in New York it's okay, attorneys can write their own subpoenas, they don't need the court to approve it, what they're leaving out is the circumstances in which they're allowed to do this. And that's huge. Federal rules are very clear. Under 26D, it says, a party may not seek discovery from any source before the parties have conferred, as required by Rule 26F, except for a couple of different circumstances, and it goes on to explain what those might be. But what about state? Let's talk about what a subpoena is, first of all. We're looking here and it says discovery, because that's what it is. Think about the case as we've seen it from start to where we are now. When did subpoenas start being allowed to be issued? It was during discovery. So first, the parties have to meet. There's no subpoenas before that. Now, what are these exemptions? They're true in federal court and they're true in state court. But let's talk about them. So if you can't put out a subpoena until everyone has met and conferred, and you have a Doe lawsuit, so there is no other side yet, how do you meet and confer? You can't. So this is one of those exceptions. So what do? You use something called pre-action discovery. There's a rule for this in the New York State Code, and it's CPLR 3102C. I talked about this in my first episode about Doe lawsuits. This is the way she should have proceeded to serve that subpoena. And in this episode, we're not even going to consider Van Zandt because that should not have happened, but that's a different topic. We're just focusing on the proper way to go about serving a Doe lawsuit subpoena. In New York, we see this code I just gave you applied here to this particular case. So what does this tell us? In order to get a pre-action discovery, you must present a prima facie case, which means you have to prove that your case is strong enough to move on to the next steps. And here's what they say. They say pre-action discovery may be appropriate to preserve evidence or to identify potential defendants. That would be a Doe lawsuit. However, it cannot be used by a prospective plaintiff to ascertain whether he has a cause of action at all. A petition for pre-action discovery should only be granted when the petitioner demonstrates that he has a meritorious cause of action and that the information sought is material and necessary to the actionable wrong. So, a valid tort. So both federal and state have these put in place. It has a pretty rigid standard, and you're going to learn more about that today, which is exactly why Blake did it the way she did it, so that she didn't have to meet the standard, because she could not have gone to the court and proven a meritorious cause of action based on what? Oh, I saw these texts that I wasn't supposed to see? No. Based on there's talk about me on the internet, and I think it goes back to Justin Baldoni's PR people? No. She never would have gotten it. So this sham lawsuit was their way around it. The law does not provide for that way around it. And if Judge Lyman allows this lawsuit to pass with no discipline, no sanctions, no nothing, he is opening up the state of New York for a million such claims as what Blake did. Do you realize how dangerous that could be? And do you know who would be the prime target of these sorts of lawsuits? Probably women. Think about this. The majority of people being stalked are women. Stalked by strangers, stalked by obsessed people who've come across their path, or stalked by their dangerous ex. Some women are hiding from these men, and it's the only reason they're still alive. Blake Lively, the newly self-proclaimed voice for women, has just exposed a way that women could be hunted down. You find yourself a Samantha? No problem. You want to rule out your competition? No problem. You want grounds for a divorce? No problem. Just go do this. If he ignores what happened in his state, he's basically saying it's okay. He's basically allowing for people to continue to do this, and it could lead to some very dangerous, if not fatal, situations. And I'm not exaggerating. Look at how easy that was. Do you know how many people know about this now? Who might attempt this now? This is some mafia stuff. And if he ignores it, then he's worse than I think he is already. and I don't have a high opinion as we stand right now. Anyone, attorney or non-attorney, who says that this is okay is dead wrong, and I've just shown you why it's wrong in federal court and why it's wrong in state court in New York. And we're going to dive even deeper. Because at this moment, Stephanie Jones is attempting to serve subpoenas for her lawsuit against Jennifer Abel and Melissa Nathan and all the folks at Wayfarer. And guess what's happening to her? She's getting doors slammed in her face, left and right. Let's have a laugh. I mean, did I say that? Let's have a look. Now, we talked about this when the Taylor Swift subpoena came into play, and her subpoena was served through Washington, D.C., which opened up a new docket. Why is that? As I mentioned at the time, so I'm not going to go into it as much as I did that time, but over a decade ago, the federal rules changed to make the serving of distant subpoenas easier on the person receiving the subpoena. So, what does that mean? It means your local court, if you need to serve a subpoena to someone that's far away, the cutoff is 100 miles. So if someone is beyond that 100-mile mark in any direction, you cannot subpoena them from your local court. It goes to their local court. Taylor Swift's went to her attorneys, and that's where they were located, and that's why we had Washington, D.C. And the reason that is to stop it from being burdensome to the person receiving the subpoena. That way, everything takes place local to them. If they want to fight it, if they have questions about it, whatever, they are represented by their local court. So this is what Stephanie's facing right now. Stephanie's in New York, but these people that she's trying to subpoena are in different parts of California. Well, guess what? Chicken butt. Sorry, couldn't resist. That means she has to serve each of them in their own part of California. And California is a big state. Lots of cities are over 100 miles apart. So that means she's got to serve it on multiple districts of California. And they've all said no. So now she's filing with the Northern District of California, trying to get them to help her compel these respondents of these subpoenas that she served. Well, let's see how easy it is for her. So here are the people who have responded with a big fat no that she's trying to compel. We have Meta, which was formerly Facebook, but it involves Facebook, Instagram. We also have Pinterest, and we'll see more about who they've also served these on. Now we see at this point, they have said no, and so what comes next? You have to meet and confer. They've done that. They've also been unable to resolve these objections, with all of the respondents saying, no, we're not complying with this. And so the statement of issue is whether this court should enforce these subpoenas. And they say we're seeking limited and specific subscriber information about Facebook and Pinterest. And they show that this relates to the case back in New York of Jones versus Abel. Then she tells her story to say that she's a victim of a coordinated multi-pronged smear campaign, falsely portraying her as someone who would betray her client's trust and publicly leak their information to further her own interest. She says it's damaged her business. And she says that these unknown petitioners have created multiple defamatory websites, including StephanieJonesLies.com and StephanieJonesLeaks.com. Additionally, other social media accounts that are promoting these websites, including a Facebook account under the name Stephanie Jones and a Pinterest account with the username Stephanie Jones Leaks. So she's trying to get to the bottom of who is doing this. It tells a little bit more information, like the bio of the Facebook, the bio for Pinterest, the logo that they share, and that they link back to this website or to each other. She says they appeared during May, around the time that Jennifer Abel was trying to leave her agency, with the assistance of Melissa Nathan. She says they were working against her while Jennifer planned to open her own competing business. She says that they objected on First Amendment grounds and refused to respond. So, what's that all about? We'll find that out later. In addition, we see these very familiar names. They've been going through it. Brianna Koslow and Catherine Case. Now remember, one of these is no longer an employee anymore. And the other, who still works there, has not been working for Wayfarer for a long time. So she subpoenaed them as well, and they served vague objections, according to her. And she surmised that their objections could only conceivably be the case if their personal information were linked to the accounts requested by the subpoena. So she's saying, well, their objection means they're guilty. She says Melissa Nathan has denied knowledge of who created the profiles or websites. And then we learned something here. Ms. Case was an employee of Jones Works prior to being hired by the agency Group PR. And from what we've been told, she doesn't take kindly to that sort of thing. Now she says counsel for Butler and Case would not confirm nor deny that they created these websites. Sort of a no comment sort of answer. And then she's saying, well, they have no First Amendment protection for account ownership information, and claims that she's established a prima facie case for defamation. She says this arises from the duplicitous conduct of Jennifer Abel, who, along with the crisis management fixer Melissa Nathan, Justin Baldoni, and Wayfarer, and additional presently unknown individuals, secretly conspired for months to publicly and privately attack Jones and Jones Works, defame both, breach multiple contracts, and steal clients and business prospects. And then they proceed to tell the story whilst misspelling Jamie Heath's name when he becomes Jamie Health. Now the accusations come from her complaint. And that's what these little references are, these ID. And then it says the paragraph numbers. And that's supposed to be the proof of her claims. So she says Abel and Nathan coordinated with business insider Katie Warren, resulting in an August 2024 article titled, Who's Afraid of Stephanie Jones? The Business Insider article was highly critical of Jones and boosted the disparaging website StephanieJonesLeaks.com, which had recently been posted by the John Doe defendants. Now, she has phone logs and texts from Jennifer's phone that show communication between her and Warren. Is that proof that she's behind this article? Couldn't it be that someone else went to Business Insider and started the whole article and they contacted Jennifer and she was simply one of many that was questioned by Warren? I mean, did Jennifer Abel put this story out or did Business Insider put it out? How are you going to go after one of the people interviewed for the story and not the person who wrote the story? That's not how this works. From what I understand, this is multiple people telling their story of what it's like to work for Stephanie Jones. Another thing, this is where free speech comes in. First Amendment. If you tell your truthful experience, it's not defamation. Jennifer Abel didn't make these other people speak. They practice their free speech too. And that's where First Amendment comes into play, that she's saying is not a part of this. But that's her misunderstanding of the law, and shame on her attorneys for not making that clear. Once Jones became aware of Abel's theft of company documents in August 2024, Abel was terminated. And then it points to paragraph 13 from her complaint, which has no proof. It's basically her saying she stole these. And one thing we know for sure is that she had Jennifer Abel's laptop scanned the same time she took her phone, and she scanned it twice because she found nothing. So where's the proof of these stolen, proprietary, and sensitive business documents and client leads from Jones Works? She has these paragraphs there, but when you turn to them, there's no proof. Abel's and Nathan's covert takedown and smear campaigns were further revealed on Abel's company-issued phone, which Jones Works recovered upon her departure. But she leaves out a lot of information right there, doesn't she? But guess what? Now, Jennifer Abel gets to respond to this in California well beyond Judge Lyman's reach. It goes on to talk about what these accounts allege, but we're going to see them all clumped together. This complaint repeats over and over and over again. It's very irritating to read. And then we get to March 7th, 2025. Petitioners served a subpoena on Meta, which is what they used to try to get this Facebook account. And here's what they requested. All basic user information regarding the account. On March 19th, counsel for Meta served their objections. On March 27th, they met and conferred. Meta indicated that it would stand on its refusal to respond. So this was all going on behind the scenes of the bigger lawsuit, which is interesting because she just now filed this motion to compel 6 days ago. So she hasn't given up. Now this is Meta's response. It says Meta objects to the subpoena in its entirety. First, it seeks information about an anonymous Meta user without first obtaining an appropriate court order as required by the First Amendment. Do you remember when I talked about this in my second episode about Doe lawsuits? And I said, because there's no opposing counsel to defend the person being subpoenaed, the court must do it because somebody has to defend their rights. And they cite this case, Smith versus Doe's 1-10. So let's look at this case. So Stephanie Smith was going through the same situation. She tried to subpoena. They said no. She files the same kind of thing, a motion to compel, but she's sending it to Twitter because she's being harassed, she says, by 3 different anonymous accounts on Twitter. She says they posted her mortgage papers and defamed her. Those are pretty big claims. Anyone would be upset to think that someone posted their mortgage on Twitter. Just like this situation, Twitter responds with a big fat no. Now, this went to the wrong district first, and they had approved it, but it's sorted out, and then it's sent to the right district, and that's the Northern District. So they said that first approval constituted unauthorized early discovery, because that's what this is. Remember, it's discovery, in violation of Federal Rule 26D1. That's the one I showed you at the beginning. It does not allow discovery before the parties have conferred under Rule 26F, or unless authorized by the court and neither condition was met. Twitter communicated to them their concern that she could not satisfy the First Amendment. What does that mean? That means that anonymous speech, including online, is protected by the First Amendment to the United States Constitution. These are things you can't mess with. What is Stephanie seeking these for? For websites, right? Pinterest accounts, Facebook accounts, and these anonymous websites. So how she thinks the First Amendment doesn't apply is baffling to me. Because it's their free speech to say these things, especially if it's their actual true lived experience. But it goes on, when a civil litigant, such as a plaintiff, asserts that an anonymous speaker's speech is actionable, the First Amendment protects the speaker from being unmasked unless the plaintiff persuades the court that there is a real evidentiary basis for believing that the defendant has engaged in wrongful conduct that has caused real harm to the interests of the plaintiff. And it cites these cases, and we'll get to those eventually. But these are the most common cases that are cited to support this agreement. So based on this reply by Twitter, the judge denies it. And she says, Twitter objects to the subpoena on First Amendment and other grounds. The plaintiff has failed to make the showing that's needed to uncover the identity of anonymous speakers. And quotes this Highfields, and you'll get used to the name Highfields. You probably won't forget it after this episode. And then says the court denies. But she's very thorough. I'm pretty impressed with this judge. She really took her time and explained it well, considered it well. So she says the plaintiff claims that someone accessed her website, obtained personal information about her, disclosed that information, uploaded her mortgage documents to Twitter, and made defamatory comments about her. She brought claims for computer fraud and abuse, invasion of privacy, civil harassment under California Code of Civil Procedure, Section 527(6), intentional infliction of emotional distress, and negligent infliction of emotional distress. And so she's attempting to sue for defamation. Now, this judge looked at the stuff, and she said it consists of 2 images reproducing this person's Twitter webpage, and the salient image is of a document whose heading contains the word mortgage, but that is otherwise illegible. So this was very deceptive, what she said, because the entire document is blurred except the word mortgage. And then it goes on to show the comments, and of course they're not nice, but they're not a crime. They don't meet the standard for defamation. And so the judge gives the governing law for her decision. She says First Amendment protects the rights to anonymous speech. She acknowledges that it's not absolute. What does it take to break that? Where anonymous speech is alleged to be unlawful, the speaker's right to remain anonymous may give way to a plaintiff's need to discover the speaker's identity in order to pursue its claim. So they have to focus on the nature of the defendant's speech. The test is the challenged speech falls somewhere beneath the most protected realm, such as political, religious, or literary, and commercial speech that enjoys lesser protection, but may be more safeguarded than pure fighting words and obscenity, which is not protected by the First Amendment at all. So, we may not like what someone says, but it takes a lot to fall under not being protected by your First Amendment right. She goes on to say it's not clear whether these were aimed at the plaintiff personally, or in her commercial capacity, or both, but the court views it as a form of social or commercial criticism. They may not be either of those things perfectly, but neither are they political, religious, or literary, which are things we are not protected for under the First Amendment, or at the other, which is fighting words or obscenity. The Highfield's capital test thus best suits this intermediate speech. So somewhere in the middle. This Highfield's capital, and we're going to review that case in a moment, but what it is it's a standard. When a case has been ruled on, usually by a higher court, and it's something that continues to come up again and again and again in courts. All the cases thereafter can be resolved simply by applying what that higher court already determined about this subject matter. And then it becomes a standard. We talked before about something like this. We had the Iqbal standard. You'll find a lot of these throughout law, and that happens when it's something that comes up again and again in court cases. It just makes it easy to have a standard that all similar cases coming in can be measured by that standard. So that's why I said you'll get used to this Highfields, because it became the standard. And that standard is two-pronged. First, you have to persuade the court that there is a real evidentiary basis for believing that the defendant has engaged in wrongful conduct that has caused real harm. So, not just said something you didn't like, not just cussed you out, not just taunted you, but had to have caused you real harm. Had this been her actual mortgage, the court might have seen it differently. But because this document was blurred, it didn't cross a line. It was taunting. It wasn't nice. Morally, it's wrong. But under this legal standard, it is not. So that's the first prong. The second prong is if they're able to get past that first prong, if they make that showing, then the court, it's not done yet, they have to assess and compare the magnitude of the harms that would be caused to the plaintiffs and the defendants, their competing interests, by ordering that the defendant's identity be disclosed. So they recognize that someone who remains anonymous could be harmed by being unmasked. So they weigh which harm is worse, even if they meet that first standard. If they determine that disclosing the identity would cause relatively little harm to their First Amendment and their privacy rights, but is necessary to enable the plaintiff to protect against or remedy serious wrongs, then the court should allow the disclosure. So those are the two prongs to the Highfields capital standard that you have to overcome in order to unmask a doe. It's a high standard. And it didn't meet it in this case. She said its allegation and speculation are insufficient. There has to be competent evidence. To what extent? To the level that it would survive a hypothetical motion for summary judgment. That's how sure it has to be. See how much time this judge took? She really went through this very carefully. She said none of the material in this case provided a real evidentiary basis. It didn't meet the first standard, and it doesn't meet the second standard either, and therefore denied. So that was the Smith case, and then it referred to this music group Macau Commercial Offshore Limited versus Doe's. That one gets cited a lot too. And we're going to go through these just to keep proving the point that time and again the courts have determined what is required for a Doe lawsuit. Because I never want you to walk away believing again that it was okay. And so that you have plenty of ammunition if someone tries to tell you that it's okay, that you can point back to this case and this case and this case. So the music case, now this one's interesting for Stephanie's case because, just like hers, there was a case in another place. So she got the okay for subpoenas in the Western District of Washington. But even with that, the power of it didn't transfer. Even though this Western District ruled that it was okay for them to obtain the information, once it was delivered, and this one was for Twitter, whose headquarters is in California as well, they said, no. They said the court in Washington didn't do it right. They didn't test it against the First Amendment. And they mentioned the Highfields test again. It's also interesting, this case, because it involves copyright infringement, unfair competition, and also breach of contract, like the sham subpoena. Now here's what happened. Defendants had used anonymous accounts on Twitter to publish disparaging remarks about this music group, its employees, its CEO. And these are anonymous, and so they want to sue them, but they need their identity. And so they've subpoenaed Twitter to reveal their identities. And they say a big fat no. They say, we do not agree. They say, we take no position on the merits of the case. We're not about that. Our issue is that this court must make the necessary legal analysis to ensure that the appropriate First Amendment standard is met and that the Doe defendant's right to anonymous free speech is protected. If this local court rules in music group's favor, sure, we'll respond. And so this Highfields test comes into play. Notice what it refers to, this identifying a Doe, early discovery, same thing as pretrial discovery. They say this Highfields is the correct standard. We see the same words fall somewhere beneath the political and all that we just read, and the two prongs that it must pass. After that analysis, the court denies the motion to transfer and also the motion to compel. And so we see they keep citing this Highfield, so let's get to the Highfield's case now. So this was way back when all of this was pretty new, and this was back in the Yahoo days. I don't know if Yahoo still exists. But Highfield's Capital was a business, and they were the largest shareholders in a company called Silicon Graphics. Now, some troublemakers got on Yahoo, some kind of message board, and they posted 3 messages suggesting that Highfields was profiting from the poor performance of SGI stock. So they wanted to sue in court in Massachusetts on the grounds of trademark infringement because the person was posing as them, defamation, trade libel, and breach of third-party contract. Here are the messages. They start off by saying it appears that this will be a very fine day. We trust our retail investor friends have taken advantage of this quarter's SGI pre-earnings rally, which occurred this morning. It's just Highfield's way of sharing important information with our smaller, yet still highly valued partners in the exciting story of Silicon Graphics. While it's always impossible to be specific, it might be expected that the stock has now returned to its typical trading range. And then one more said we're going to buy a new corporate jet, a Gulfstream 4. It will have custom Zebrano wood trim and Corinthian leather seats with plasma TVs. Best of luck to our retail friends today and tomorrow. So yeah, someone's definitely being bratty. Yahoo removes the posts after Highfields reported it, and another one comes up, and it's removed. So Highfield says, we made a substantial investment in time and money to develop, establish, and promote the Highfields Capital mark. And now this is costing us, and so we want to sue. They come before a magistrate first, and it's Judge Wayne Brazil, and he rules against them. He does not grant them the subpoena. So they come back to the district court, and they file a motion for a de novo review. Now, a de novo means anew, or from the beginning, or afresh. What that means is that a higher court will look at a ruling, but not like they look at an appeal, where the judges do consider all the decisions that were made and why. This one completely disregards the decision and sees it with fresh eyes, as if they're hearing it for the first time. This is used when there's a question of whether or not the law was correctly applied. I know a case we'd love to see looked over with fresh eyes, because it seems questionable whether or not the law was correctly applied. De novo. Anyway, without getting too far off the subject, magistrate judges are lower-level judges. They're not appointed by the president like district judges are. They're appointed by judges. And they handle a lot of preliminary work. A lot of times it's in criminal cases. They'll do things like sign off on warrants. They'll handle initial appearances, arraignments, simpler things like that. So they would be beneath a district judge. So it's brought before a district judge to see whether this magistrate judge made a mistake. But she finds that Brazil did not err by requiring plaintiff to show, with respect to its claims against defendant, that there is a real evidentiary basis for believing that the defendant has engaged in wrongful conduct. We see these same steps. Plaintiff must make a concrete showing of a prima facie claim of actionable harm. And she said that the evidence must be sufficient to demonstrate that defendants committed an unlawful act. So there has to be a claim to be made before you can grant this. That's what was lacking with Blake, and it's what's lacking with Stephanie. Was there an unlawful act or just something they didn't like? Internet criticism is just something you don't like. We all get it, everyone on the internet. If you're a content creator, at some point someone's going to come along and not like you for some reason or not like what you said. Some people get obsessed with it. Some people are unwell. They say things. We might feel creeped out about it even. As you know, that fake lawyer on Reddit, Kat, was trying to figure out who I am. That was creepy. But I don't have a claim against her for it. But these things happen, and you have to understand that when you come to social media. Understand some people are not well, and they're going to do these things. And so she says that having reviewed the file de novo, that she adopts Magistrate Judge Brazil's recommendation and accordingly finds that the plaintiff has failed to make a sufficient showing that the defendant has engaged in wrongful conduct, causing harm to plaintiff. Is it morally wrong to do what they did? Of course it is. It's not nice. They set out to be hurtful on purpose, but that doesn't meet the legal definition of wrongful conduct. The statements, as she says, were sardonic commentary. The speaker is advancing by sarcasm the opinion that plaintiff is not knowledgeable enough to put its clients and or itself into favorable investments. It's kind of like a bad review sort of thing. And plaintiff failed to demonstrate that a reasonable person perusing the message board at issue would understand the statements as having been made by plaintiff itself. They're saying, obviously, this wasn't you. A reasonable person reading this knows this wasn't you. And just like that, a standard was born. This judge made history with this. The Highfields capital case. Remember that name when you need to defend this. Another one they mentioned, and I couldn't help but notice, they snuck in 2 cases that are from, guess where? The Southern District of New York, exactly where Blake's case is being handled. We have this one, this Mirza versus Yelp, and then this other one, Alcon Vision. We're not going to cover Alcon Vision. That's to do with context. It's really long, and it's not a doe. But Mirza is. And this time, they're trying to compel Yelp because they don't like a bad review they got. The review stated, "It's the worst experience I've ever had. I woke up looking like a monster, cheap product, and he's absolutely not experienced, nor does he care." So this was a doctor and presumably a patient that wasn't happy or someone pretending to be a patient. But let's see how this goes. Now what's interesting is we have that rule about subpoenas. So Yelp is in the Northern District of California, but it asks, can we transfer to the Southern District of New York? Because they felt that its interests would be protected in this district. That's where the case was pending. But rather than have it in their own neck of the woods, for their own convenience, they're like, oh, this is going to go better for us in the Southern District of New York. Because this was an issue of choice of law, that has to be established first. And there was consent, so they allowed that. But then, in the very district where Judge Lyman sits, in the very state where Blake got her Doe lawsuit, what did they determine? Anonymous internet speech is protected by the First Amendment. They say the same things. It's not unlimited, though. And what do they apply? The same standard, Highfields, that involves a real evidentiary basis for believing the defendant engaged in wrongful conduct that caused real harm to the interests of the plaintiff. I know this is repetitive, but I want you to be able to remember it. Statements of opinion are not actionable, as an opinion cannot be proven false and therefore does not give rise to liability for defamation purposes. A lot of the same words we saw just in this lawsuit not that long ago, loose, figurative, or hyperbolic tone. The statement is one of opinion. All these things we saw. And they say, plaintiffs have not made a sufficient showing of a prima facie defamation claim under New York law, as the review read in context would be perceived by a reasonable person to be nothing more than a matter of personal opinion as to the quality of plaintiffs' products and services. New York courts have consistently declined to find anonymous reviews actionable for purposes of defamation. This judge also does a really good job considering many cases. I highlighted this one, Sandals Resort, because this one came up in my earlier episodes about Doe lawsuits. And see, right here, this judge, Judge Lyman's colleague, sitting in New York, cited the Sandals case because it happened in New York as a reason for not approving a pre-action discovery to identify a doe. It's not okay, and it's not okay in New York either. Courts routinely consider whether a plaintiff has stated a prima facie case for defamation in addressing motions to quash subpoenas. Remember, Blake's sham lawsuit was based on a breach of contract? Well, this had that claim in there too, and the judge noticed that. She's like, there's no arguments as to why. The existence of a valid contract between a plaintiff and a third party, there isn't. The defendant's knowledge of the contract, the defendant's intentional procurement of a third party's breach of that contract without justification and or damages. These are the things you have to prove a tort of breach of contract. It doesn't exist here, just like it didn't exist in Blake's case. And so, look at that. Denied. This is exactly what Blake would have faced if she had actually had her sham lawsuit reviewed by a judge. If she had done this properly, never would have happened. And that's just their first point. The second point, to the extent that you believe a defendant or interested party may be associated with the page at issue, the subpoena imposes an undue burden on non-party meta if you have not first attempted to obtain this information from those individuals. Another reason Blake would have failed. She knew exactly who she was going for. And I'd love to see how she served the subpoena to Stephanie. Did she ever officially serve it? Because we know she already had the information before. Leslie Sloan had already seen it. So how is this subpoena served? But this is another thing she would have faced. And now the footnote gives us 4 things that have to be established to seek information about an anonymous non-party witness. Now, this is something newer. This is from Pinterest Inc., 2023. So this is newer than Highfield's. The subpoena seeking the information was issued in good faith and not for any improper purpose, like to sanitize stuff you already have that you shouldn't have. 2. The information sought relates to a core claim or defense. She didn't have a claim at the time. Her claim was breach of contract. 3. The identifying information is directly and materially relevant to that claim or defense. Breach of contract? Again, failed. 4. Information sufficient to establish or disprove that claim or defense is unavailable from any other source. She knew the source, so this doesn't even apply to her. So this is why Blake did what she did, because her case never would have stood up. Stephanie must be so mad that she made it so easy for Blake and now she's not getting to do anything. And without these subpoenas going through, her case is going to fall apart. And she might end up with criminal charges. So, I don't subscribe to karma because I don't believe in rebirth. But I believe in you reap what you sow. Very much. I believe in consequences for your actions. And I believe it's starting to happen. These two, in my opinion, spoiled brats. Both married to very powerful men with a lot of money. Not used to being told no. Used to living off of the power of their husbands. Something happened to them they didn't like. They're spiteful. They wanted to lash out. They were too impatient to try to do it the right way. And they wanted to overreact to something that happened to them. And push blame on people that they can't even prove did anything to them. And look at how it's backfiring. And they still don't even realize they're in the wrong. That's what's maddening, is if you asked either one of them today, they would still think they were right, in spite of all of this. Then they end with saying, contact me if you want to meet and confer, which now we know that definitely happened. So we know they also petitioned Pinterest. They wanted communication and documents between Pinterest and the owner of Stephanie Jones Leaks, any agreement entered between them, and subscriber information for that account. March 21st, counsel for Pinterest served objections. They met and conferred twice, once March 28th and again May 19th. Pinterest said, big fat no. And if it looks familiar, it's because it is. It's the same law firm. They represent Pinterest as well. And so they use all of the same arguments, cite all of the same cases, but there's something extra they add. A fourth, they say all discovery requests must be relevant to a claim or defense, proportional to the needs of the case, and not a mere fishing expedition. So they're on to her immediately. They know what she's doing. And then here we saw their names come up that counsel for Koslow and Case would not confirm or deny. They object to the subpoenas, but look at this. This is disturbing. And the way she won't let these two go, well, now we've got one answer that one of them used to work for her. But I think by this one, because look what she's after. Network utilities, WhatsApp, Signal Messenger, Meta Platforms, IPXO. And IPXO is a company that deals with IP addresses and VPNs. And M247 Europe is a hosted cloud service. This is way over the line. And this tells me that she looked into every nook and cranny of Jen's phone. But see, here's the thing. The other stuff she can say, well, this is my company phone. I can access her messages and her emails. That's her work stuff. But no one's going to say she had a right to look into WhatsApp or Signal or Facebook or Pinterest or Instagram. None of that stuff. That's all private, even on a work phone. So this tells me that she's read all of that stuff and knows there's something on there that she wants. And she's trying to wash it clean with a new subpoena. Because you know what? Not everybody has WhatsApp. I don't have Facebook. I don't have Signal. I don't have these 3 other things. Not everybody has WhatsApp. So the fact that she's asking for these things, she knew they existed on there. And we know she was telling Jennifer's old colleagues stuff about her and that she had access to her pictures, things like that. She was all through Jennifer's phone. But this right here shows her for who she is. And I hope that the response that comes, they're going to tell these people the entire story of what she did to get Jennifer's phone. And that's going to shut her down completely. And then she was still after Koslow and Case. That wasn't enough. All those just mentioned on the last one. We also have AT&T Wireless, Google, Pinterest, and Verizon. And everybody's saying, no, you cannot have their data. She's sitting on all those messages. She can't use them. And yet somehow, after going through all those cases that we just went through, all those responses that said, no, 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 Stephanie, She's still demanding that she's established the relevance of the information sought. And she starts bringing up the underlying litigation in New York. And then she says these First Amendment objections are of no moment. The subpoena requests users' information which isn't subject to First Amendment protection. And I've established a prima facie case for defamation. And she says this over and over and over again, as if she keeps repeating it, it's going to be so. But how did they miss where the First Amendment protection comes in? It comes in with your free speech to what you say on these platforms, which is exactly what she's trying to sue for. How is it not subject to First Amendment protection? And then she says the court should reject the First Amendment objections because the subscriber information sought is not protected. No, but their actions, their speech is protected. You don't get to look them up because what they said is their right to say. How do you not understand that? I'm wondering, does her attorney not get it, or is she forcing her attorney to write this nonsense? And then she's saying, well, even if the First Amendment is okay here, I made a prima facie showing. No, you didn't. And then she says, well, the account holders have been notified. Yeah, and they object. She says it again, prima facie showing. Like I said, she just repeats it. It's just over and over. And I'm looking at this and I'm like, Stephanie, are you well? Are you okay? You don't seem okay. You might need to go lay down. Here it is again. Petitioners have established a prima facie claim. And then here we get to what was said. Now, you saw some of the things that have been before the courts before, the things that were said, the way they were taunted, things like that. Now look at these. These are the best she's got to put on here to fight this. Holding clients hostage. If someone says they felt like they were being held hostage because there was an enormous guy standing at the door blocking their exit, that's their opinion of what happened to them. After receiving a notification following another unsuccessful hacking attempt, we decided to have a bit of fun and look into the penalties for computer hacking, as in Connecticut. So the website was making a joke that they'd gotten hacked, and Connecticut's where Stephanie lives. Okay? They said Jones cries and screams at her clients while collecting substantial monthly fees for below par fake PR. Stephanie doesn't understand how to truly do PR outside of leaking her own clients' secrets. Are these not just like the reviews, the bad reviews we saw? Stephanie doesn't fight for her clients, but she does fight with them, crying, screaming, keeping them hostage. Stephanie Jones takes clients hostage. You already said that, Stephanie. Are you well? With Stephanie, once she learns the bad, it becomes her toll and her weapon. I don't know if that must mean tool. The more baggage a client comes to her with, the better positioned Stephanie is to ensure they don't leave her unscathed. Stephanie's known to leak information about her clients to press so that she can save the day for them and inspire their gratitude. And she's been so successful in carrying this out over the years, she influenced not just her own business, as clients are either scared to leave or can't due to a sudden turn in public perception. Not only does she break confidentiality, she willingly does regardless of the possible damage this kind of behavior might cause. And it does have a cost. Everything in some cases, from reputation to brand and movie deals, partnerships, philanthropic opportunities, sponsorships, the list goes on and on before it even gets to positive press. These continued leaks affect clients' ability to do business as their news is never safe. Stephanie holds her employees in the same contempt. If she finds out where an employee is going when they quit, she's been known to call their new company and tell them they've made a mistake in hiring them. Again, it's like bad reviews, and these are possibly truth. None of this appears to meet the criteria for defamation, which we know is very high. And now this footnote is even more unhinged. The StephanieJonesLeaks.com website was taken down and no internet archive remains available. However, the content on StephanieJonesLeaks.com and Stephanie Jones Lies was identical. So she's like, there's no proof, but it was just like this one, so it's got to be the same people. That's not going to hold up. That's not going to hold up. The conclusion: petitioners issued subpoenas to respondents Meta and Pinterest for legitimate, non-harassing reasons, says the harasser, allegedly, to determine the identity of the users who created defamatory social media accounts and websites. Respondents' First Amendment objections are of no moment. How did you get that? There is no First Amendment right implicated in identifying user data, but your reason for going after them is what they said on social media. That's what's protected. So my conclusion, seeing what she's going through, how hard it is to get these identifications, knowing what we know about how hard defamation is, knowing what we know about that Megan Twohey interview that was on NPR that some of us just recently became aware of, where she says that Blake told her that what happened wasn't the worst she's experienced in Hollywood, that she's experienced worse, and that she never intended to make it public until what she calls this retaliation. Now, when you put all that together, you have a story. Defamation, terribly hard to prove because of the malice standard. Getting IDs in the proper way for does, terribly hard because of First Amendment rights, which bounce you right back to that malice standard. Stephanie set up a way to grab Jen's phone. She knew she was quitting. She surprised her 2 days before. She wanted those contents. She got those contents. She immediately looked at them, got angry. In her spiteful rage, she reached out to the enemy. Blake, likewise filled with spiteful rage, made a plan. Her attorneys no doubt told her she didn't have a strong defamation case. They no doubt told her she couldn't get a subpoena the right way. But Blake, being Blake, wouldn't have liked that. What if there was an easier way? I mean, compared to all of these things, retaliation's pretty easy to prove, isn't it? Retaliation for what? The easiest claim for a woman to make, especially in California. You see, there's a new law. Blake, but right here are the texts. I can prove it. I have them. Shh. Now, let me call Samantha. Does that sound more like it? And you know what makes me mad? Is that Judge Lyman is fully aware of all of those cases we just read. Fully. When he granted those motions to dismiss, he knew that Friedman was gathering this proof together, but he didn't wait. Not only that, he granted them with prejudice to make sure that none of that proof that what they were getting together could be used. And he took so many liberties and made so many poor choices in his decision that even now, as we pick through all of those pages with a fine-toothed comb, we're finding more and more problems, more and more mistakes, more and more misapplications of law. Why was he so dead set on granting those motions to dismiss that he wrote 132 pages guaranteeing that those cases would fail? I have never seen a judge so bent on one side making it. Never, as this case seems to be. We got to keep talking about this. And the most important talk is talk with legal standards to support it. When it comes to bad decisions he made, find the case laws that prove it was a bad decision. Talk about it. Share it. We're not spreading harm. We're spreading truth. We're not telling lies about somebody. I'm talking about spreading legal standards to support decisions and legal standards that are against decisions he made. That's what I'm talking about. This is Cassidy O'Connell saying stay well, stay mad, and stay tuned.